In this module, we're going to be taking a look at lineups, show-ups, and the review of photographic evidence with the aim of identification. So keep in mind, there are 4 constitutional rights that are invoked in these processes. The right to counsel, the right to due process, and the right against unreasonable searches and seizures, and the right against self-incrimination. So, for instance, the right to counsel is not absolute. The right to counsel must first be considered in terms of 2 stages. If you have been formally charged, a formal charge requires counsel. If the suspect has not been formally charged, there is no requirement for counsel. For a show-up, same thing. If there has been a formal charge, right to counsel is invoked, it's required. Before a formal charge, no, not required. And then for photographic identification, the review of those photos, no right to counsel. Now, the easy one is due process, because due process is always required. But the right against unreasonable searches and seizures? Well, there really isn't a search or seizure as long as the police officers stay within the bounds of prescribed behavior in lineups, show-ups, and photographic evidence review. Same with the right against self-incrimination. The suspect, the person in custody, is not actually being questioned. Even though that there are things being told about them, there's evidence being derived or gathered in the process, it is not considered an interrogation. Lineups don't involve, at least legally, any form of interrogation. And so this Miranda warning is not even required. Now, if the lawyer is present, that's good, but there's going to be a limitation on what that lawyer can and cannot do. They might have the label or the function of the interested observer. So certainly, they can ensure due process rights are enforced. Certainly, that can always happen, but the lawyer's not required. So here's some things that can be required of someone beyond merely just looking at them. Blood samples. You can take a photograph. You can require them to give a handwriting sample or a fingerprint or other kind of palm print, something like that. And you can make them repeat words or gestures. For instance, if there was something that is just stuck in the mind of a victim or another witness, if a bad guy says, "Stick 'em up," and the words and the language and the tone is just frozen in the mind, you can have everyone in the lineup say, "Stick 'em up," and it may jog the memory. They may be able to more accurately identify. So a show-up is a one-to-one confrontation, and this is serves a similar purpose to a lineup, a little bit different. If someone is in the midst of a situation that's going on, there may be an opportunity for someone to identify a witness, not in a lineup at the station, but sort of immediate. It's more ad hoc. So the right to counsel during show-ups is similar to that of a lineup. If there's been a formal charge, right to counsel. If there hasn't been a formal charge, no right to counsel. Photographs, as you might imagine, are less invasive. Although the 4 constitutional rights I mentioned are invoked, there's no right to counsel in photographic identification. There is a right to due process, but it's rather limited. We want to make sure that we're not overly suggestive as law enforcement officers in providing photographs for a victim or other witness to identify. You can imagine if everyone was 100% sure that it was a male who was 60 or older, and you had one male who was 60 or older, and you had 4 18-year-old females in the pictures, that would be overly suggestive, right? There's only one option, and that's rather absurd and obnoxious. But you can imagine that there's a spectrum between that and what might be considered perfectly constitutional. So due process is invoked. Now, this is something to think about that goes beyond what you need to know as a law enforcement officer or as a prosecutor, defense lawyer, or a judge, or any other participant in the criminal justice system. Eyewitness identification. Now, there's actually much written about this, but it seems to me to be the case that most people think that eyewitness accounts are extraordinarily helpful and reliable. Most people who study this or who have participated have a different view. So it could be argued that eyewitness identification has declined in reliability. My personal opinion, it hasn't declined. It's never been good. People make mistakes all the time. We see something, our brains are magnificent, we put things together, and it may or may not actually be the case. If you're interested in philosophy, and you're interested in epistemology or metaphysics, there's a lot written even from a philosophical point of view about what we should do, on which we can rely, those kinds of questions. But here's something to just drive this point home. Of 100 documented cases in the U.S., and we're talking about cases in which a convicted person who has actually served time in prison has been exonerated by DNA evidence. It wasn't him or wasn't her. It is estimated that over 75% of these exonerations that have been documented, over 3/4 of them, were mainly the result of eyewitness identification mistakes. So what can we do about this? This is sort of a policy, procedure. I also think it's something that we should be mindful of. I think, to be fair, we ought to talk about eyewitness identification with the jury members. Right, a jury panel, they ought to be informed. If their job is to weigh the credibility of the evidence, if their job is to provide an actual weight to be given if they find someone credible, I think they should know about this. So some states have actually enacted some laws to make their lineup and eyewitness identification procedures more reliable on purpose. I mean, a prosecutor has sworn to see that justice is done, not just win cases against defendants. And so there is an ethical duty in the prosecution side to ensure that if there is an eyewitness identification made, and that is essentially on which the entire case hinges or hangs, that it is reliable. Not just to sort of secretly say, well, I'm going to win this case because this person identified that person. So this is actually important. It's important to civilization, to communities, to families, and to individuals to bear the weight of finding an actually innocent person guilty is a very heavy burden. And so this is not just something to talk about in a classroom. This is something I hope that you continue to think about, continue to discuss, and to be aware of, no matter what you do in the criminal justice system. So even the Department of Justice, which is a federal department, has given guidelines after studies to help law enforcement at the local level, county level, state level, federal level, to conduct lineups and show-ups and photographic identifications. We don't want mistakes. We want clarity and we want certainty. There are other ways, as you might imagine. There are many, many TV shows where forensic scientists are engaged in accomplishing the task of gathering evidence and producing it. And there are mistakes that are made there too, but everyone thinks that DNA testing in their head is better than a mere eyewitness. I say everyone, that's my opinion. So DNA testing, what it does is it matches a suspect's DNA with the DNA that was recovered from the scene. So if there was no DNA left, obviously you can't do that. And there's an Innocence Project. It was going on when I was in law school, and so far, as of the writing of this textbook, there have been 289 post-conviction DNA exonerations in the United States. That is troubling. If you keep in mind that who is doing these projects, it is largely nonprofits and volunteer pro bono. Not all. It's largely a group of lawyers who are donating their time or work for legal aid, or defenders, public defenders of some sort, who are engaged in this behavior, law school students, law professors. The fact that 289 have been exonerated, well, it's a good thing, because if they didn't do the crime, they shouldn't be in prison for it. But it's a bad thing that this has to exist. So there's a check on the criminal justice system after the case. So these post-conviction writs, habeas corpus and things are helpful to address things that have been unjustly done. You've heard about polygraph, lie detector test. To my knowledge, I have never seen a polygraph test that actually admitted. There have been polygraph tests that have been used, not to be admitted at trial, but to provide some level of additional scrutiny, and cases have been resolved because of it. I have not participated personally in any of the cases, but I know of them. But the reliability of polygraphs is largely questionable. So this is not from my practice, this is not from my experience, this is literally from watching movies, but I'm pretty sure that CIA officers and maybe those in elite military training facilities, there are ways to train yourself how to beat a polygraph. I would not be able to. I'd have no idea how to do it, and it would probably be rather helpful if someone was trying to detect whether or not I was being dishonest. I have no training whatsoever, but it seems to me that it can be beaten. Whether or not many people could do that, I don't know. But it's not about people who are intentionally trying to beat it. It's that it's not reliable. We can't tell when someone is or isn't. We can only have best guesses. And so far, the United States court system has not allowed this, especially in a criminal conviction. So in addition to just eyewitness accounts or photographic evidence or lineups or show-ups, there's some other ways we can identify subjects or suspects as well. That is, breathalyzer test. Well, that's a little bit different. You may think, well, don't you use a breathalyzer test to determine whether or not a particular suspect or the subject of a criminal investigation is driving while intoxicated? Yes, but assuming that there were more than one of the persons was driving, you can actually use this to identify people, not merely to determine if someone that you already have in custody is drunk. Mostly used to decide whether or not there's probable cause that someone needs to be arrested for driving while intoxicated, but also can be used to identify people. Handwriting samples. I've never used one or experienced one in any kind of a case that was criminal, but I have used handwriting samples to prove up a case in civil side. Personally, it wasn't that difficult. I had a witness who was familiar with the handwriting and identified it and authenticated it that way. Brain fingerprinting is really one of those subjects that is way beyond my experience. It sounds like science fiction to me, much like facial recognition probably would have sounded to someone 25 years ago, but to you and to me is rather normal. I've used my face to open my computer and unlock it. Your phone might do this. This has been in existence for at least a dozen years. That's quite normal, but that was pretty high tech. And I would imagine, and I would like to suggest, that the facial recognition technology and the databases that the federal government and maybe state local governments have is far more sophisticated than merely just using the software to open your phone, but same kind of technology. So keep in mind these constitutional rights that apply when they don't apply fully, those that never go away as you're thinking about these sort of straightforward ways of identifying people in a lineup, a show-up, or the review of photographic evidence for the purposes of identifying people.